Well, thank you very much. I'm really grateful for this opportunity to comment on a very interesting paper on political ignorance and originalism by Ilya Somin. I think Ilya is the only one who could have written it. He is the leading theorist of political ignorance in the academy, and he's had the imagination to apply his knowledge of the extent of ignorance to illuminate many areas of the law. My remarks will be divided into two, tracking what I think should be a fundamental distinction in thinking about originalism. Originalism as a positive theory and originalism as a normative theory. I don't think political ignorance has so much relevance to the best theories of originalism as a positive theory of meaning. On the other hand, I think Ilya's focus does have potential implications for the attractions of any normative theory of originalism that sees the process of constitutionalism as part of its attractiveness. Nevertheless, in a normative world, the attractiveness of originalism depends on the alternative. And on this comparison on political ignorance, originalism still does well because the constitution-making process militates against ignorance in a way that the judicial updating process does not. Let me take these points in turn. First, political ignorance is of limited relevance to positive theory of original meaning that predominate today, at least in the academy. Occasionally in the paper, Ilya suggests that originalists think that the Constitution thinks what the public, meaning kind of a majority of the people, believe it to mean. But I don't think most sophisticated original meaning originalists rely on the majority at all for positive meaning. We can see this by a kind of reductio ad absurdum. It's very probable that a majority of the people didn't even know the full text of the Constitution. After all, some of it concerns obscure subjects, court preferences, for instance, of which most lawyers have remained happily ignorant. Yet this ignorance would not mean that that did not have a settled meaning, at least under the definition of positive meaning defined by a reasonable and informed person, the predominant metric of originalists today. Ilya says at one point that informed people may have different values, but I don't necessarily think that different values matters when it comes to positive meaning, because even an uninformed individual asked about what the Constitution meant would likely have said what it means what to someone who's well-informed and knowledgeable would think it would mean. And similarly, I think the same with respect to its legal rules. It would be a reasonable observer who was knowledgeable about the legal rules, and an uninformed person would refer to that meaning. To be sure, it's possible that originalism may matter more to positive theories of originalism not so widely favored, like forms of original intent where some specific group of people are determinative of the positive meaning. But I agree that the degree of political ignorance is potentially relevant to the normative attractions of originalism. One argues that the original meaning of the Constitution should bind us today because of process values, like the supermajoritarian consensus it represented or its popular sovereignty. These arguments seem weaker if public ignorance results only in an attenuated relation between the Constitution and popular consensus. But any normative argument about constitutional theory must avoid the nirvana fallacy. We must compare the effect of political ignorance on the attractiveness of originalism and its principal competitor, living constitutionalism. The constitution-making process tempers the problem of political ignorance in the ways I think Ilya does not fully capture. In contrast, political ignorance is a huge problem for living constitutionalism because it creates a huge amount of slack between people and elites that make the decisions to update the Constitution. First, I think the comparison is not the knowledge of constitutional law, but what the process of constitution-making does to help people be more knowledgeable about the provisions of the Constitution than in ordinary politics or even an understanding of constitutional law in ordinary times. Part of this aid comes from the form of supermajority rules that limit the serious proposals on the table. Another part is the nature of the Constitution itself. Because it entrenches proposals for the future, it attracts more attention in this constitution-making process and creates an atmosphere of solemn deliberation. But there's more than theory to support this view. There's evidence. And I really recommend to both Ilya and everyone in the audience the wonderful new book by Pauline Maier, Ratification, The People Debate the Constitution. There, I think, shows that people were connected in, I think, an unprecedented way in the history of the West with a decision of such momentous importance. As she notes, the debate occurred in newspapers, taverns, coffee houses, over dinner tables, as well as in the Confederation Congress, state legislatures, and state ratifying conventions. In Pennsylvania, the state legislature ordered the Constitution be read publicly to large crowds of citizens and be copied in English and German and distribute it throughout the states. And it was emphatically not debate among the elites. As the Boston American wrote at the time of the Massachusetts ratifying convention, the body now convened is perhaps one of the completest representations of the interests and sentiments of their constituents that was ever assembled. No liberal or mechanic profession, no denomination in religion or party in politics was not present. Ratification by a representative assembly means that the Constitution will tend to reflect the values of people even if they don't know all about its intricacies. This is particularly so, in my view, if it's interpreted in accordance with traditional legal rules, rules that resolve ambiguities according to purpose, structure, and yes, on occasion, expected applications, because these connect the values of the people at the time to the text. Moreover, the ratification process also created a stronger feedback between experts and public than ordinary politics. The Federalist Papers are now the best known, but scores of essays, both critical and supportive of the Constitution, were published. Thus, experts explicated the Constitution as the diverse body of relatively representatives, ratifiers, deliberated on it and ratified it. The representatives of the public provided an endorsement of the broad outlines after hearing experts fill in the details. Now, I think the amendment process is somewhat similar than the original. I just don't have time. And here I won't, though, refer to history, but refer to my own knowledge. I remember the Equal Rights Amendment and that debate. It was an extraordinary debate that roiled the campus, and when I was brought people, speakers of all kinds to campus to debate not only the text, but the implications of the Equal Rights Amendment about whether it would create a right to same-sex marriage or unisex dorms, some of which I thought extravagant claims at the time of its implications. Now, being a constitutional law professor, I'm much less sure. But in any event, it was an enormously productive and time of a real kind of debate that you don't often see in ordinary politics. Contrast this outpouring of public interest in constitution making with the poor public monitoring of judicial updating in the modern era. Most non-lawyers have little knowledge of the Supreme Court's daily business. Even the identities of the justices are not well known. Thus, elites have substantial slack with which to play because they don't have to present an issue for supermajoritarian ratification. Then there is the problem of what I would call boiling the frog. The court can update slowly and incrementally. Each individual decision is surely beneath the public's attention, but the cumulative effect may be very dramatic. In contrast, in the founding or the amendment process, the public gets a chance to understand the constitutional provision whole. Of course, some decisions like Roe versus Wade may capture the public imagination. But even there, the court can choose when to act strategically when the public is unlikely to be able to respond. And effective political responses cannot be directed at simply the constitutional decision. One can agitate, of course, for appointments of justices to overturn the updating, but justices, their appointment in a presidential election, are bundled with many different issues, and issues that may be greater importance to the pocketbook of citizens or their concern for the safety of the nation. This diffuses their focus, and that rationally reduces the public incentives to understand the constitutional issues at stake, because they're not likely to be able to do much even in the political process. Finally, as Mike Rappaport and I have shown, judicial updating undermines the amendment process. It undermines it because it becomes an alternative to the amendment process, and that itself is problematic if you believe that this process, the process of constitution making, tempers a public ignorance. Now, to be sure, I am not at all suggesting that Ilya is not on to an important point when we come to public ignorance. It is a concern, of course, but in the world we have to think about it in comparison to the alternative. And thus, in my view, while Ilya's paper provides an interesting spotlight on a little discussed aspect of the Constitution, the real question to me is a comparative one. And the constitution-making process still, it seems to me, to provide enough knowledge to the public to make the normative values of originalism still attractive compared to its alternatives. Thanks very much.